Hello, I'm professional attorney and very much amateur musician Scott Lesowitz, and unfortunately we have another garbage copyright infringement lawsuit. This one involves the Bruno Mars song When I Was Your Man and the later Miley Cyrus song Flowers. And interestingly, Bruno Mars did not join this lawsuit. What happened was one of his co-writers in the song had sold his rights to an investment company, and that investment company is the one suing for copyright infringement. I think it says something that none of the other writers, including Bruno Mars, joined the lawsuit. Now, I do have to say, while I pretty strongly believe this is not infringement, I do have to say that the songs do sound somewhat alike, but that doesn't mean it's infringement. So here first is a clip from When I Was Your Man.
Same bed, but it feels just a little bit bigger now. Now my baby's dancing, but she's dancing with another man.
And now here's a relevant clip from Flowers.
I can buy myself flowers, write my name in the sand. I can take myself dancing.
So what the complaint does is it has four, graphics, or we'll call them exhibits, where they show a snippet of the sheet music from When I Was Your Man and a snippet of the sheet music from Flowers, and claim that, they're so similar to each other. It seems to me what they're going to argue is that, none of these four things on their own may be copyright infringement, but four things together plus some other, similarities, well, that together is original enough to, be protected by copyright and to be infringement. And at the end, I'll go over some legal cases that I think, show this and why I think they're going to lose. But first, let's look at these comparisons. I'll say first that the When I Was Your Man was in C major and Flowers is in A minor, so the notes are the same in each scale. All right, so here's this first set of similarities. And yes, they each have, an A minor chord and a D minor chord, but, big deal. It's two chords. I mean, the rhythm is, different. So as for the melody, now here there's more clearly similarities. Most notably, there's a 5 notes in a row that occur in both songs. So E, D, C, E, F. But again, the rhythm is different. And under the law, it's pretty clear that this similarity by itself would not be found to be infringement. It wouldn't even get to go to a jury to decide. So the question is going to be whether the judge thinks, well, if you take this and other similarities they're pointing out, do they together equal a possible finding of infringement? I think it should not. I think it should not go to a jury. Look, there's only 7 notes in a scale. There's only so much you can do with pop music, but I could see a judge allowing it to go to a jury. Okay, so now here is the second exhibit. Again, the notes used are the same. The chords are more or less, similar. There's some similarity in the rhythm, but it's different. And the notes are, most I see in a row here is 4. It's not like I'm saying it's nothing and like there's, no similarities, but for copyright infringement, it has to be substantial similarity. So here is the third slide. And look, here they don't even bother writing the notes in. I mean, you could just, if you look at the sheet music though, you can kind of see why. I really, this one is like, I just really am not sure what they're going for here. And then here is the fourth comparison that there is. And this one actually is probably, I guess they saved the best for last, maybe. Again, though, the rhythm's not identical. The notes here, at least, it's closer. Like each one has G, A, E, D, C at the end. So that's 5 notes. And there's one chord in common. So this case was filed by way in federal court in Los Angeles, so it's within the Ninth Circuit Court of Appeal. And the case that, to me, obviously, this is hearkening to is the blurred lines case. I did a whole video on this. It went into length about it, so I'll at the end, I'll post a link to it. But in that case, they did just have an expert come in and point to a bunch of you know, sort of similarities like this, and then it was enough to let the judge have it go to the jury, and then you know, Robin Thicke was like the worst witness ever and totally unlikable, and so the jury smacked them down, even though in my opinion it was never, the court should have thrown it out. And the Blurred Lines case went to the Ninth Circuit Court of Appeals, and in a 2-1 decision, it affirmed, but the dissenting judge had a fiery dissent because the majority basically said, well, you know, we were very deferential to juries. But then the dissenting judge kind of got her revenge where they affirmed the finding of no infringement. This is the one involving Led Zeppelin's Stairway to Heaven. The jury found no infringement, and the Ninth Circuit there had really good language about how you cannot just throw out a bunch of random crap and claim infringement. There are times in copyright law where you can take a number of elements that are not original by themselves and arrange them in a sufficiently original manner. You can get copyright protection for that original arrangement. So here's what the Ninth Circuit said. These disparate categories of unprotectable elements are just random similarities scattered throughout the relevant portions of the work. Labeling them a combination of unprotectable elements does not convert the argument into a selection and arrangement case. And then there was a later Ninth Circuit case involving the songs Joyful Noise and Dark Horse, where this was a really good one. The court did a really good job here, in my opinion, where the jury actually found infringement. And then the trial judge had the, strength, let's say the fortitude, to overturn the jury's decision and instead find no infringement. And then it went up to the Ninth Circuit, and the Ninth Circuit affirmed. So this is what the court had to say. Joyful Noise and Dark Horse contain similar arrangements of basic musical features, mainly in that both employ the pitch progression 3-3-3-3-2-2, played in a completely flat rhythm. This combination is unoriginal because it is really nothing more than a 2-note snippet of a descending minor scale with some notes repeated. Allowing a copyright over this material would essentially amount to allowing an improper monopoly over 2-note pitch sequences or even the minor scale itself, especially in light of the limited number of expressive choices available when it comes to an 8-note repeated musical figure. All right, with that, thank you for watching and take care. And hope I'll see you later.